Welcome back to Law Stash Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. A while back, I published a 5-part series dealing with vehicular searches without a warrant. This remains one of the most popular series that I've ever published here on YouTube. In every part, we discuss all the exceptions to the warrant requirement as they relate to vehicles. We're talking about automobile exceptions, inventory searches, consent, and so on. One of those exceptions is search incident to arrest. If you get pulled over and the officer is going to arrest you, he can search the vehicle, but there are requirements. And today we're going to look at another Ninth Circuit case that deals with search incident to arrest, and we'll review what are those requirements for the officer to comply in order for the evidence to stay in. Otherwise, the evidence that's found on you will be suppressed and cannot be used against you in trial. Before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button, sharing my channel with your friends and family. It really helps grow this channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States v. Ruckus. This is a Ninth Circuit case and it deals with search incident to arrest. Before we go on, let me give you some factual background. Mr. Ruckus is driving on an interstate. He gets pulled over for driving 15 miles per hour over the posted speed limit. When the trooper comes up, he asks Mr. Ruckus for the usual: his driver's license, proof of insurance, and registration. Now, Mr. Ruckus tells the officer that he does not have a driver's license and doesn't have any form of identification. Now, when the officer approached, he saw in the middle console some loose change, some money, and a pill bottle that didn't have any labels on it. The officer asked Mr. Ruckus for his name and birthday. The officer went back to his patrol vehicle, ran the background check on Mr. Ruckus, and found out that Mr. Ruckus had a suspended license, which was done to force him to pay child support. Now, at this point, the officer told Mr. Ruckus if he had anybody else available to pick up the vehicle, because he would not let Mr. Ruckus drive on a suspended license, and under their policy, he would have to impound the vehicle for 30 days. Mr. Ruckus told the officer that the vehicle was technically registered to his mother, but she was not available to pick up the vehicle at this point. So, what did the officer do? He got Mr. Ruckus out of the vehicle and began searching inside. During his first search, he found some cocaine in the middle console of the vehicle. He then placed Mr. Ruckus in handcuffs and into his patrol vehicle, and then conducted a second search. There he found in the vehicle a 9mm loaded handgun. Mr. Ruckus gets charged being a felon in possession under 922G, and he also gets charged with a number of drug-related offenses, namely possession of cocaine with intent to distribute. Mr. Ruckus later files a motion to suppress and says that his Fourth Amendment rights were violated because the officer had no right to search his vehicle without a warrant, and the search incident to arrest did not apply. Now, before we go on, let's look at the law. What does the Fourth Amendment say in this situation? Week after week, you hear me talk about the basics. The Fourth Amendment guarantees the right of the citizens to be free from unreasonable governmental searches. Subject only to a few specifically established and well-delineated exceptions, a search is presumed to be unreasonable under the Fourth Amendment if it is not supported by probable cause and conducted pursuant to a valid search warrant. Now, if you think about it, most of our automobile searches are done without a warrant. They're done on the street after an individual gets pulled over. But because cars are mobile, the Supreme Court has carved out exceptions to the warrant requirement in the automobile context. However, officers must still possess probable cause to conduct a search. Now, what you just heard is obviously what's called an automobile exception. It is discussed in my part 3 of the 5-part series on vehicle searches without a warrant. So after you watch this video, go back and watch the part 3. There we discuss all the details of automobile exception. Obviously, the vehicle has to be mobile. And we talk about the degree to which it has to be mobile. Some of my cases that I discuss in that part deal with motorhomes and mobile homes, vans, different types of vehicles. It is important to figure out exactly what kind of vehicle we're dealing with. And with automobile exception, the officers still need to have probable cause to believe that incriminating evidence will be found inside the vehicle. Even though the officers are not required to get a warrant, the idea is that the warrant would have been issued if they had time to go and get the warrant. But because we're dealing with automobiles and they're mobile, they just simply can't get the warrant because it's not feasible. This is your automobile exception. In this case, it simply doesn't apply. Remember, Mr. Ruckus gets pulled over because he has a suspended license, but really, first he gets pulled over because he's speeding. Then the officer finds out he has a suspended license, and so presumably that's the crime. Well, the probable cause here is that he's driving on a suspended license. That does not give the officer a right to search the vehicle inside, because what's the evidence he's looking for? Clearly, he's not going to find the driver's license inside the vehicle. After all, it is suspended. Now, of course, there's that pill bottle inside the vehicle, but I would say that the pill bottle alone would not give the officer probable cause to search the entire vehicle. Now, I would think this is all extra. In this case, the court did not even talk about the automobile exception other than giving this brief description on what it is. All of this is extra. And the reason why I'm telling you this is because maybe the court believed that the automobile exception simply didn't apply, or maybe the parties did not even raise it. So the court moves on and talks about search incident to a lawful arrest. So let's go on and talk about that. In United States v. Robinson, the Supreme Court explained that in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a reasonable search under the amendment. So was born the search incident to arrest doctrine, which permits officers to search an arrestee's person subsequent to the arrest of that individual. The rationale is now applied in the automobile context. Belton answered the question of the proper scope of a search of the interior of the automobile incident to a lawful custodial arrest of its occupants. There, the court considered the impact of Robinson and Chimel v. California, which held that a permissible search incident to arrest may not extend past an area within the immediate control of the arrestee on the search of arrestee's automobile. In doing so, it developed the workable rule that when a policeman has made a lawful custodial arrest of the occupant of an automobile, he may, as contemporaneous incident of that arrest, search the passenger compartment of that automobile. Then came Arizona v. Gant, a Supreme Court case that put some limits on the applicability of Belton and said that when we're dealing with search incident to a lawful arrest related to automobiles, that exception only applies in two situations: where the person who is being arrested is unsecured and within the reaching distance of the passenger compartment of the vehicle, or number two, whether there's reason to believe that evidence of the crime related to the arrest would be found within the vehicle. Now here, of course, even though the officer found a handgun inside the car, at this point, Mr. Ruckus was already in handcuffs and placed in the trooper's vehicle. So he was not within the reaching distance of his own vehicle, and he was in handcuffs. And then, of course, we're dealing here with a suspended license. The second situation also doesn't apply. The officer would never be able to find any sort of evidence related to a suspended license within the vehicle. So because neither of these two situations apply, search incident to a lawful arrest is not a valid exception in this case, says the court. So if you would think, if these were the whole facts at this point, the court would not be able to use any of the evidence found against Mr. Ruckus, including the firearm and the narcotics. But of course, the court goes on to another exception, inevitable discovery. In this case, the officer had a lawful right to impound the vehicle after giving Mr. Ruckus an opportunity to have his mother pick up the vehicle. Because she was unavailable, the officer was in his legal right to impound the vehicle. And when they do an impoundment, there would be inevitable discovery of all this evidence because the officers would have to do an inventory search of the vehicle. So search incident to a lawful arrest does not apply, but impoundment does. So these are the lessons that I want you to learn. Hopefully this case taught you a little bit more about search incident to a lawful arrest. Of course, there has to be a lawful arrest, and search incident to arrest only applies in two situations. Hopefully you still remember those. And if you do, please give a thumbs up for this video, share my channel with your friends and family, subscribe to it. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks a lot for watching.